Now, back to On the Market on 105.9 The Region.
You're listening to 105.9 The Region. Welcome back to On the Market, York Region's only radio real estate show. I'm station manager Tina Cortez, and my co-host is Asif Khan with RE/MAX Prime Properties.
Thank you, Tina. Joining us next is Ricky Rathore. Ricky is an owner at RE/MAX Empire and also principal owner at Rathore Baig Law Firm. Ricky, welcome to the show.
Thank you for having me. Always a pleasure.
Ricky, the hot topic right now with inventory shrinking seems to be assignments. There's so many people looking to assign their properties or even purchase assignment properties. Maybe take us through, first of all, what an assignment is and how people can move forward with that.
Absolutely. So assignments absolutely are a hot topic right now. In essence, what you've got is somebody who's entered into a contract. When you sign a contract, you're doing two things. You're creating rights and obligations enforceable in a court of law. And by virtue of an assignment, you've got one party that's trying to step out of the contract and have somebody step into their shoes by definition.
And what does that entail? So suppose I've purchased a condo 3 years ago and it's 2 years in, it's almost ready, and I say, you know what, I don't have enough money to close on this condo, or, you know, I just want to cash out and take my money and put it elsewhere. What's the next step?
So absolutely, you're exactly right. So some people don't have the money; they need out of the contract. They need to make sure that they don't get sued. So they're finding someone to replace them and step into their shoes. There's people who are also looking to cash out. So the main motivation to buy that property was to profit out before actually closing it and paying the land transfer tax and everything else. And then you've got certain people whose intentions have changed or their circumstances have changed such that they need to get out. So they find somebody to take over that contract, and in essence, they're looking to back out of that deal or step aside so that someone can fill their shoes.
Now, when you're talking about assignment sales, then, are there tips that we should be aware of that maybe are not obvious either to the buyer or to the seller?
Absolutely. So when you're getting into somebody else's shoes, you want to make sure you know where they've walked around in them. You want to know what the contract entails. You want to go through the terms and conditions very carefully. And so as a lawyer, one of the number one inquiries that come through my office is, can you review our contract? And most people, including us and as brokers and agents, will make their offer conditional upon lawyer's review, which is critical. Because when you go out and, for example, buy a brand new property with a developer, as a condo, for example, there's hundreds of pages worth of documents. And so before you agree to take over someone's contract, you need to know what you're signing up for. Otherwise, you could be setting yourself up for disaster.
And if you're a purchaser and you're thinking about purchasing something now with the anticipation that you're going to assign it in the future, not close on it, but assign it prior to it closing, there's certain things that you have to watch for when you're initially purchasing that property from the builder itself, such as, you know, what is the assignment cost? Are you able to sign it? When are you able to assign it? So maybe tell us a little bit, Ricky, about what we need to put into our original contracts with the builder in order to make the assignment that much easier.
So what's really interesting, Asif, is that when you negotiate a contract with a realtor, they're usually using the OREA contracts, which are very balanced contracts between buyers and sellers. On the other hand, when you're drafting a contract or signing a contract rather drafted by a builder, most things in that contract benefit the builder. They're not designed to benefit a buyer in any way. And so it's critical. What we do from our law office perspective is that when a purchaser says, Ricky, I'm going to go out and buy a brand new property, we actually equip them with a 3-page schedule, which is designed to deal with some of the nuances and intricacies of that contract, which are designed to supersede those terms so that people can set up assignments and arrange those things and avoid the hidden costs that are usually associated with these sorts of arrangements.
But what if you don't know going in, when you purchase a condo from a builder, you don't know that you're going to sell it before closing or before you actually have possession? What if it comes up along the way? Then what do you do?
So Tina, that's exactly what happens. Most people intend on closing the property. And so now Asif knows better than anybody else the way the market is right now. It's very tough with stress testing and lending requirements and everything else. And so you've got people that are just looking to walk away from the contract, even in some instances lose a little bit of money because they don't want to risk getting sued by the developer, which is key. And so when you structure the contract from the get-go, the one thing you do want to make sure is that assignments are permitted. More importantly, what are the costs associated with them so that when you, if and when you end up in that situation where you need to be able to get out, you have the opportunity to do so. So on that topic, as an example, you want to make sure that when the builder consents to it, they don't put red tape all over it. Most of these contracts say you can't put the listing on MLS. So if you can't market the property on MLS, how do you expose it? How do you get the right person to fill your shoes? So you're really looking through exclusive channels at that point, which make it very difficult to try to advertise that property and actually get rid of it. I actually had a really funny situation about 2 weeks ago where a buyer told me that he wanted to add his wife to the agreement. The way the builder's contract was structured was that he had to pay $10,000 to add his wife so that she could qualify on the financing with him. So it gets really, really, really crazy.
And these are things that need to be negotiated with the builder. So you can cap it. You can say, I will pay you $2,500 for an assignment. There's a lot of different ways that you can protect yourself as a buyer through the builder's contract and have those changes made by your lawyer to protect yourself.
Yeah, and you have to really look at it because it's not just the assignment fee. There's the legal fees as well. Right? And so there's a handful of big law firms that deal with these sorts of contracts. I can't air them out on the air, obviously. But in essence, again, you do want to go back and make sure that the proper terms and conditions are in the contract so that if you need to do something, you can.
The other thing is, Ricky, maybe you can help us out here too, is there's that period called occupancy in between when the building is completed and when the building is registered for actual closing. During that occupancy, what do you look for and what are the intricacies there in assigning a condo or a house which has been purchased? Well, it doesn't really happen with houses unless it's a condo townhouse. What do you look for there during the occupancy period, and are you able to assign it during that period?
Great question. And at the end of the day, it all comes back to the contract. So most builders put into their agreement that you've got a time bar in the assignment. If you don't assign it within a certain number of months or weeks before the actual occupancy or final closing, they basically say you forfeit the right to do that. So timing is key. Making sure that you structure your affairs so that you have financing in place and everything else is really important, because if you end up with your back against the wall, you're going to end up in a really funny situation.
CRA, how do they handle this?
So CRA, I mean, we, as taxpayers, it's a self-reporting system. So at the end of the day, it comes down to your intentions. And that's a funny part, because I might have intended on buying this property, closing it eventually, but then my circumstances have changed. And so the CRA looks at it from two perspectives predominantly. One, if you're buying it with the intention of flipping it, well, by definition, you may be considered a builder, at which point the assignment, the way it has to be structured, you're going to end up paying HST on the deposit as well as the purchase price. So it's critical that you make sure that these things are very clear in the beginning, because if you're doing it, and there are people that I represent that buy properties for the sole purposes of flipping, and they have to understand the HST implications. Whereas if you're somebody in an unfortunate situation that needs out of a contract, well, then that's a different thing. Again, at the end of the day, if you get audited by the CRA, you have to be able to prove your case.
And you pretty much have to have it rented out for a year. If you're taking over an assignment or purchasing an assignment, you pretty much have to have it. You have to be the final user of that property. So you're moving in or you're leasing it out for at least a year to get some sort of credit back.
That's right. So there's normally up to $24,000 of credit that you're eligible for. There's two predominant programs. One is if you're going to own or occupy the property and the key thing here is principal residence. You have to occupy the property as a principal residence to qualify for that. If you qualify for that, basically it's the credit on your statement of adjustments given to you by the builders. So you're coming up and you don't have to pay that up front because the builder deals with the CRA in that capacity. If the builder suspects that this is a flip or it's not something that's going to be principally occupied by you or an immediate family member as defined, in that situation, they would say, hey, you got to pay it up front. So that's another $24,000 you didn't account for. Now, under the other program with the rental rebates, it turns out that you have to have a 1-year lease agreement. So that means that if you've Airbnb'd it during the short-term rental period or something like that, that might actually contradict your license with the builder, which will put you in a funny situation. Most people don't know, and they'll put the property available on MLS to be rented, and your license doesn't permit you to do that. So you have to really make sure that you've structured the agreement or reviewed it carefully so that you don't end up, renting the property to somebody. Now you're dealing with the landlord tenancy board. You're dealing with a vendor who wants vacant possession because you can't close, and it's going to cause a whole bunch of issues because it may be considered a resale by that time, and then you forfeited the deposit. Not the deposit, the rebate rather.
It sounds like there are so many scenarios and options that you have to examine. That how do you keep this all in check?
Absolutely, Tina. So, you're buying a property, not a bag of cookies. And so it's critical. Most people, they're happy to pay money on an inspection. They're happy to pay for the small things here and there. But you have to keep in mind that one of the most important things you can do is have the contract reviewed by an attorney. If you don't do that, then that's how you set yourself up for disaster. And you have to go through these scenarios with your attorney so that you have plan A, plan B, plan C, and you have that escape if you need it.
Ricky, one last question. So I assign my condo to someone else and that person is unable to close on it. What happens then? Am I off the hook? Am I still on the hook? What happens in that situation?
So when we started out, we started talking about contracts by definition. So again, when you're entering into a contract, you're creating rights and obligations enforceable in a court of law. What's generally accepted is that when you're signing your agreement, you're assigning your rights to the contract, not your obligations, which means that if the new person who's taking over the contract and filling your shoes cannot close and uphold their end of the bargain, the builder may be able to sue you jointly and severally and come after both of you in full.
Well, that was a great explanation of that, Ricky. Now, thank you very much for joining us. If listeners have questions about assignments, how can they contact you?
Absolutely. You can check us out at rathorebaig.com or give our office a call at 905-554-7465, and we're happy to help.
Awesome. Thank you so much.
Anytime.
When we come back, we get to your real estate questions and this week's hot listing. And just a reminder, if you missed any part of our show, go to 1059theregion.com and click on schedule to find On the Market and a list of our other shows. You're listening to 1059 The Region. Stay with us.
Need to connect with Asif Khan from RE/MAX Prime Properties? Call him 416-988.